The Equality Act is the UK's main anti-discrimination legislation. It was passed by the outgoing Labour government in 2010 and then came into force later in that year after the coalition government under the Prime Minister David Cameron came into power. The intention of the Equality Act is to protect people from discrimination, harassment, victimisation on grounds of 9 protected characteristics such as sex, religion, nationality. I'm probably not going to be able to list all 9 of them, pregnancy, age, disability, race, and gender reassignment. Not sure if that was all 9. It also includes a public sector equality duty, which is sort of an active duty on public authorities to take account of the different effects that policies and decisions might have on people with these various protected characteristics, and to try to foster good relationships between them. More prosaically, the Equality Act brought together what had been a quite complex patchwork of separate discrimination laws covering the different characteristics that had arisen over time, and it also implements EU directives on anti-discrimination and equal treatment. Interestingly, the Equality Act also includes a section on socio-economic equalities, as well as those personal protected characteristics that I mentioned earlier. Thankfully, that part was never brought into force, although interestingly, it has been in Scotland in certain ways with respect to public authorities. The Equality Act has given rise to a lot of litigation across the economy and also in private lives and interactions as well. It covers not just employment relationships, but also the conduct of business, the provision of goods and services, and also the activities of clubs and organisations, for example. It's given rise to a lot of litigation in employment, lots of cases to do with sex discrimination, which are now very common. We had a rather unusual and surprising case to do with the gender reassignment and sex discrimination characteristics, the Jaguar Land Rover case that actually lots of lawyers think was wrongly decided, but that actually extended protection to people who claimed a non-binary identity. And obviously HR departments have had to do a lot of work and put a lot of policies in place, and often act in rather cautious and rather bureaucratic ways now to try and mitigate their exposure to liability under these kinds of claims. And then we have the claims in respect of the supply of goods and services. Probably the most famous of those would be the Ashes Bakery case, or the gay cake case, which, although this was under the Northern Ireland equivalent of the Equality Act, was a classic example of the clash of rights that can happen under the Equality Act, where we had a gay person who wanted to order a cake with the message "support gay marriage" on it, and a Christian bakery that didn't want to support or endorse that message. And that case ran for years probably, and went all the way to the European Court of Human Rights, where ultimately the rights of freedom of expression and freedom of religion of the bakers were held to prevail. But that's an example of the kinds of controversies that this has stirred up. And then the other much more current controversy that's going on at the moment is the rights of transgender people, and in particular their rights to play in the sports categories of the gender that they identify as, or indeed use facilities such as toilets and changing rooms that accord to the gender that they identify as. In fact, the Equality Act does allow discrimination on basically on all of the grounds, I think, as long as it's a proportionate way of meeting a legitimate aim. And the legitimate aims can include things like protecting the dignity and privacy of women in same-sex services. And in fact, there is a special reference to sports being allowed to run same-sex categories. However, certain activists had pursued rather particular self-serving interpretations of these kinds of exceptions and created a lot of uncertainty in the law in pursuit of self-identification prevailing over sex-separated services. And the Equality and Human Rights Commission, which is the main regulator under the Equality Act, recently issued some guidance to try and clarify the single-sex exceptions. The EHRC guidance was met with a lot of horror from activist groups who support the rights of transgender people to access services and spaces that accord with the gender that they identify rather than with their biological sex. Now, in my view, as a non-specialist lawyer in this field, the Equality and the EHRC gave a pretty reasonable account of the law. My main concern is that the EHRC guidance, to my mind, though, does illustrate why the Equality Act and the anti-discrimination legislation within it is somewhat misguided, and also because what they're trying to do is so extremely ambitious in legislating every single activity in our economic and social lives is ultimately quite incoherent and leads to lots of almost illogicality as well as legal uncertainty. So in my ideal world, we wouldn't have an Equality Act at all. We wouldn't have any anti-discrimination legislation. We would respect property rights and freedom of contract, and we wouldn't assume that by default populations, service providers, employers are all going to be voraciously discriminating or unintentionally, recklessly discriminating indirectly against people given half the chance. And in fact, if people want to offer a service for women just because it's what they want to offer and they think it's what there's a section of society of women who would like to use a same-sex service, even if it's not strictly necessary for their dignity and privacy, then you should be allowed to offer that service. And the same really goes for all of the similar protected characteristics. And some of it we might find utterly repulsive and repellent, the idea of a racially segregated restaurant or hotel. But at the same time, who's going to go to such a place? And surely the market will determine that it wouldn't be very successful, even if you did try and run one. Similarly, I've seen adverts near where I live for a new retirement home for gay people, which seems to me to be perfectly fine. If you want to see out your days with like-minded people who've shared similar experiences to you throughout their lives, that seems to be perfectly valid to me. And I assume that they've checked the Equality Act and they are actually allowed to do that. And so therefore, what is the problem that we're trying to solve here that couldn't be resolved with due respect for these fundamental, as I say, property rights, freedom of contract, freedom of association, and so on, that wouldn't involve all of this legal uncertainty and micromanagement of private relationships?